case briefs, and so much more. LSData's got what you're looking for.
The Arizona Supreme Court heard a case in 1946, Ross v. Bumstead, which revolved around the question of who is responsible for a loss that occurs after a property sale contract is signed but before the sale is finalized. The case involved an agreement in which a property, including personal assets and water rights, was to be sold for $75,000 in installment payments. Possession was to be given upon delivery of title papers and deeds, while taxes, water assessments, and insurance premiums were to be prorated based on the agreement date. 8 days after the agreement was made, a fire destroyed a packing plant and warehouse on the property. As a result, the defendant stopped payment on a $5,000 check he deposited and refused to complete the contract, arguing that it was conditional and that the risk of loss should fall on the vendor. The vendor filed an action to recover the difference between the selling price as agreed and the actual selling price to a third party, but the defendant claimed the contract was conditional and pleaded partial failure of consideration. The lower court ruled in favor of the vendor, and the defendant appealed the decision. The Arizona Supreme Court ultimately upheld the lower court's judgment and affirmed the principle that, in a contract for the sale of realty, the buyer assumes the risk of loss, according to the majority rule.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.